The Code on Wages 2019 is now fully operational across India. This legislation consolidates and replaces 4 legacy statutes: the Payment of Wages Act, 1936, the Minimum Wages Act, 1948, the Payment of Bonus Act, 1965, and the Equal Remuneration Act, 1976. The primary objective of this consolidation is clear: to streamline the legal process and to guarantee the right to minimum wage for every worker in the economy. Let us decode the key provisions and technical compliances in detail. First, consider the universalization of minimum wages. Under Section 5, every employee, whether in the organized or unorganized sector, is now legally entitled to a minimum wage. Under Section 9, the central government will determine a floor wage, below which no state government is permitted to fix its minimum wage rates. The second critical shift lies in the definition of wages. As per Section 2Y, wages include basic pay, dearness allowance, and retaining allowance. However, if your exclusions, such as house rent allowance or overtime, exceed 50% of the total remuneration, that excess amount must be added back into the wages component. This will have a direct financial impact on the calculation of provident fund and gratuity contributions. Payment timelines under Section 17 have been made stringent and uniform. Daily wagers must be paid at the end of the shift. Weekly employees must receive payment on the last working day of the week. Monthly employees must be paid before the expiration of the 7th day of the succeeding month. Most importantly, in cases of resignation, dismissal, or removal, the full and final settlement must now be completed within 2 working days. Regarding the annual bonus under Section 26, eligibility remains at a minimum of 30 days of work within an accounting year. The bonus range is statutorily fixed between a minimum of 8.33% and a maximum of 20% of the wages earned. This code represents more than a compliance checklist. It signals the dawn of a new corporate culture. Under Section 3, discrimination on the grounds of gender in matters of recruitment or wages is strictly prohibited, reinforcing the principle of equal pay for equal work, with greater legal weight. For employers, Section 51 has abolished the old Inspector Raj, replacing it with the role of an inspector cum facilitator. The regulatory focus has shifted from punishment to compliance. First-time offenses are no longer subject to immediate criminal prosecution, but can be compounded. However, do not mistake this for leniency. The penalties for non-compliance remain severe, and the limitation period for employees to file claims has been extended to 3 years under Section 45. This necessitates that employers maintain their records, registers, and wage slips, whether in physical or electronic form, with absolute precision and transparency. These changes offer employers legal clarity while ensuring financial security for employees. In conclusion, the Code on Wages 2019 establishes a balanced, progressive, and transparent ecosystem. These regulations are not merely administrative formalities, they are the bedrock of a secure and equitable workplace. As responsible professionals, adhering to these mandates is both our legal obligation and our ethical duty. Thank you.